Welcome to U.S. Immigration TV. Can an illegitimate child be petitioned by his or her father? The answer is yes, but there are several requirements that the father must meet in order to be able to petition that child, or if the father is a U.S. citizen, to get a U.S. passport for that child. These requirements include, most importantly, the father demonstrating that he had supported the child or was a part of that child's life up until the child's 18th birthday. It's very, very important to document that the father supported that child. And I've seen many cases where the father had attempted to petition his out-of-wedlock child only to have the petition denied. Now, this requirement applies only to fathers who are petitioning their out-of-wedlock children. It does not apply to the mother. Now, what basically is required is demonstrating you have provided support like remittances. And it's very important that if you are sending remittances to your child back in your home country, make sure the remittance documents the fact that it is for that child. For example, if you're sending the remittance to the mother, the grandmother, or an aunt who's looking after the child, certainly you're going to send it to them because the child may be young, but put somewhere on the ray line, the memo line, that it is for the child. Because I have had cases where the father had sent the remittances and sent it to his sister, the child's aunt, and USCIS said, well, how do we know this is for the child versus you're supporting your sister? Make sure that is documented. Have pictures together. Save your letters and your emails to that child. In other words, make sure you have documented you've been a part of that child's life up to the 18th birthday. And when it comes to U.S. citizens, when they want to obtain a U.S. passport for the child, it is also important. In fact, one of the requirements is the U.S. citizen has to have agreed in writing to support the child up until the 18th birthday. It's a very simple, like one-page document where the father has that agreement. If that is not signed before the child's 18th birthday, then it could be that the father would not be able to obtain a U.S. passport for their out-of-wedlock child. If you are a father and you have an out-of-wedlock child and you want to petition them or obtain a U.S. passport for them, I would strongly recommend that you seek the advice of an attorney who can evaluate the situation, help you gather the appropriate documents demonstrating eligibility and that you have supported the child and have been a part of that child's life so that the case can be approved. Now, I'm not guaranteeing results, but having an attorney assist you can greatly increase your chances of success. I hope you found this video informative, and I will continue to post other videos which I believe may be of interest to people out there. So don't forget to like, share, and most importantly, subscribe. I'm Michael Gurfinkel, and this is U.S. Immigration TV.